Case of the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Mr. King, Ms. Brady, Ms. Higgs, Ms. Nelson, and Ms. Spengler. And the people are represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Ms. Titch McGuire, and Mr. Edson. We are outside the presence of the jury. Are the parties ready for the jury?
We are, Your Honor.
Okay, let's bring the jury in, please.
Your Honor, I do have a couple of brief matters I should probably bring up with the court.
Oh, okay.
First of all, Your
Honor, we are expecting that we'll be calling Dr. Jonathan Woodcock this morning, perhaps the second witness. And in reviewing Dr. Woodcock's reports and notes, we've located what appear to be three or four areas that seem to be subject to the court's orders, at least arguably. And I identified those for Mr. Brockler this morning, and I just wanted to bring them to the court's attention. Because I believe these are subject to the court's orders, I'm not going to ask any questions about them. I've instructed Dr. Woodcock that I'm not going to ask him any questions about them and that these are not relevant topics. He's in the courtroom right now, so that the court knows. But the topics would be, number one, initially when we sent him in to see Mr. Holmes on the 24th of July, 2012, one of the primary reasons was to assess competency to proceed. And I understand that that's not an issue for this jury. It's not an issue that's relevant at this point in time, and it's been excluded by the court, so I'm deliberately not going to ask any questions about that. Secondly, there's the potential issue of what Mr. Holmes' desires might be about the potential outcomes of the trial. There's a statement that he made to Dr. Woodcock that he didn't care, something along the lines of he didn't care whether he got the death penalty or not. I'm not going to inquire about that. And finally, Judge, I'm not going to inquire about any issues that would bring up issues of future dangerousness. And those are the three issues I just wanted to bring to the court's attention.
Okay. All right. And obviously, all my orders related to Dr. Reed apply to some extent to your experts. And I issued those orders at your request in terms of excluding anything or limiting anything. It was done at the defense's request, and it wouldn't make sense to have excluded it with respect to Dr. Reed and then allow someone else to talk about it. So it applied with Dr. Metzner. It applies with the defense experts, and so the defense should be talking to its experts, and then the prosecution has to be careful not to elicit those statements or not to go into those areas during cross-examination.
And I anticipated that was going to be the court's feeling, and I've instructed Dr. Woodcock on what the court's orders are and told him that if he reaches a point where he doesn't know if he can answer a question, he should just indicate that he doesn't know if he can answer the question pursuant to the court's orders or not.
All right. Thank you. Mr. Brockler?
And I appreciate Mr. King giving me that information in advance, and I agree with the court's orders. The one area that I think is of concern here with Dr. Woodcock is when he's sent into the jail at the request of the Public Defender's Office back on July 24th, it appears to be precisely and only for the purposes of determining competency. It does not appear to be a psychiatric evaluation for any other purpose than that. And so being able to cross-examine him on the fact that he did not, in that first meeting, explore with him some of the other areas that he's now going to bootstrap into his opinion of March 26th of this year is important, I think, to testing his competence and credibility before the court.
Well, my order on competency, my recollection, Mr. King, is that what I excluded was any results of any competency testing. Is that correct?
I believe that's correct, Your Honor. Any opinions about competency? I have no objection to Mr. Brockler asking questions about the scope of the interview that Dr. Woodcock did with Mr. Holmes on the 24th. And I can tell the court the only purpose wasn't competency. There were other purposes as well. That was one of the purposes. But if he wants to explore that, I'm going to have no objection to that.
Okay. So if he says your understanding is that the purpose of your examination was to assess competency without going into any results of that examination or any opinions about that examination, you're saying that's okay.
I would ask the court for instruction on that. I would think that would violate the court's order, but
Which order do you think it violates? It seems to me that's appropriate if Mr. Brockler wants to attack his credibility or the reliability of his opinions by saying, hey, you wrote this report on sanity a year later or 2 years later or whenever it was, and when you went in there to meet with him shortly after the shooting, what you were asked to do or what you were doing was evaluating his competency. Now, he may not be able to get into what he was asked by counsel. I don't know whether he will or not, but I think it's fair for him to say what his goal was as he went in there to talk to Mr. Holmes. Does that make sense?
it makes sense, Judge. I think that the problem is it raises a question in the jury's mind of whether Mr. Holmes was found to be competent or not at the time. And I think that's the irrelevant issue before this jury. That's a determination for the court and not the jury. And so I think Mr. Brockler can ask questions about the scope of the questioning and what the questioning related to without bringing up the issue of competency, without saying the word competency and without bringing that up. I could tell the court that Dr. Woodcock's testimony is going to be that he went into, other than competency, he went in to observe symptoms and give his initial clinical impressions.
Okay.
Mr. Holmes.
Mr. Brockler, can you satisfy your goal, if you will, by asking whether he was requested to conduct a sanity examination at that time?
At this point, Judge, I will, and I'll say this further. If I feel like there needs to be greater exploration of that, I'll approach the court before I start going into that area. I won't just do it from the hip.
Okay. Let me just tell you that I don't believe that it would violate any of my orders to have Mr. Brockler question Dr. Woodcock about whether one of the goals of the initial meeting was to assess the defendant's competency. But I do understand the concern that was just expressed by Mr. King, that if you allow that, then the jury might wonder, well, what was the result of that? Or is the defendant competent now? Was he competent at the time? And we probably want to avoid those types of issues. But Mr. Brockler, if you get to a point where you think you need to go into that, then ask to approach, and then we'll see what we do about it. And if I allow it, then perhaps we can come up with I can come up with an instruction for the jury. But it would be better if you stay away from it. And for now, it sounds like you're agreeing to stay away from it. And then if you think at some point you need to explore that, then you will approach the bench and ask for permission to do that.
Yes, Your Honor.
Okay. Mr. King, was there something else?
Just one other issue very briefly, Your Honor, and that is we anticipate today and tomorrow, I think, for the most part, that we will be, as the court anticipated when the prosecution admitted the jail video of Mr. Holmes in the holding cell, we're going to be seeking the admission of 3 different jail videos that I referenced in my opening statement that took place in November of 2012. I haven't provided copies of these to the prosecution this morning because we got them from them. They were provided by the jail through discovery, and so they have the videos. The versions that we would be seeking to introduce would be unaltered, unedited versions of those 3 videos.
All right. And are these some of the videos that were shown during opening statement or different videos?
Yes, these are. I showed portions of these videos in opening statement. The 3 videos are, one of them is just a couple of minutes in length. I think another is 6 minutes in length. And then the third is, I think, around 2 hours in length.
Okay. Mr. Brockler?
Your Honor, I imagine that's accurate. I just don't think we'd be doing our due diligence if we said, hey, we take the public defender at their word that these videos contain what they say and are unedited. I think we need to be scrutinizing the evidence the same way they would ours. So to the extent that they have the ability to provide us copies in advance of playing them, we'd like to use some of our downtime from court to review those and just make sure they're exactly what they purport to be.
All right. Do you have a copy of them?
Yeah, we have copies right here we can provide
All right.
to them, Judge.
Please.
Yes.
Thank you.
I hate to backpedal, Judge, but Ms. Nelson just pointed out to me in court's order in D-185 on page 4, the footnote number 6, indicates, during the trial, the parties should avoid references to competency testing, evaluation, or analysis in order to avoid prompting questions from the jury related to the determination of the defendant's competency or the results of competency testing.
Right. But the order, I think, was aimed at the results of the competency testing, if I remember correctly. And I said that because of the concern that you expressed earlier, which I agreed with, or which I share, which is that if you allow some testimony about competency, the jury may then wonder, well, what was the result of the competency evaluation? So,
Understood.
okay. All right. Anything else?
No, not for the defense.
Great. Okay, let's bring the jury in, please.
The three that we're going to introduce.
Please be seated, everyone. The record should reflect that the jury has joined us again. Good morning, everyone. I hope you enjoyed the lengthy break that we had. At the end of the day on Friday of last week, the prosecution rested. I have been mentioning to you throughout the trial that the defendant is presumed innocent, and that presumption of innocence remains with him and must be given effect by the jury throughout the trial, and that the prosecution has the burden of proof. The prosecution has to prove beyond a reasonable doubt each and every element of each crime charged. And so the defendant does not have to present any evidence, but the defendant may present evidence if he wishes to. And so at this time, let me inquire of defense counsel to see if they wish to present evidence on behalf of the defendant. Mr. King?
Yes, Your Honor.
All right. Call your first witness, please.
Your Honor, the defense would call Jason Frank.
Good morning, sir.
Good morning.
Could I have you raise your right hand for me, please, so that I can administer an oath? You solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
All right, please be seated. Please tell us your full name for the record and spell your first, middle, and last names.
Jason John Frank, Jason John Frank.
All right, make sure you speak into the microphone, please, so that we can all hear you. Mr. King, you may proceed.
Thank you. Good morning, sir. How are you?
I'm good, thank you.
Can you please tell us how you're employed?
I work as a registered nurse at the Arapahoe County Jail. Been there approximately 5 years. I also have a small business doing muscle activation techniques.
Okay. When you were you employed at the jail as a nurse in November of 2012?
Yes, through a staffing service I was.
Did you ever have contact with an inmate named James Holmes in your regular duties at the jail?
Yes, I did.
And do you recognize him here today?
I do.
Do you recall, sir, on November 11th of 2012, at 3:32 hours, there being something aired over the radio in the jail referenced Mr. Holmes?
Yes, I do.
And what was that?
I was working in booking, covering in the infirmary because we didn't have a nurse at that time. Usually on the weekends we don't in there. And there was an emergency called, so I responded from booking. At the time that I got there, they were escorting Mr. Holmes to the behavior side of the holding cells over there.
And is that the side where they house people in what's called the rubber room that doesn't have
Yes.
any furniture in there.
Yes, it is.
Were you able to then review a videotape of Mr. Holmes jumping or falling off of his bed in his solitary cell there?
Yeah, I had to, actually, as he was walking, I asked him if he wanted me to check him out, and he said he was okay and refused, so I went and checked on the camera to make sure he didn't hurt his neck or anything. That was the best I could do.
Okay. And have you had a chance to, if I can approach the witness, Your Honor.
Yes, you may.
Sir, I'm handing you what I've marked as DTR 67, and I'm handing that to you now, sir. Do you recognize that?
Yes.
What is that?
This is the CD that I was shown recently, just the video that was pulled from his cell when the incident happened.
Does that have your initials and today's date written on it that
Yes,
you
it does.
reviewed that? And is that a fair representation of the video that you reviewed of the events that took place on the 11th of November 2012 that you just testified about?
Yes.
Judge, I'd move the admission of the exhibit.
Is there any objection?
No objection.
All right, without objection, D-TR-67 is admitted and may be published.
Judge, I have no further questions of this witness, and I'd ask to publish the exhibit when he's done, or if the prosecution needs to review the exhibit first, I would have no objection to that either.
How long is this video?
I think this is 2 minutes, or 6 minutes in length. 6 minutes in length.
All right, and it doesn't have any sound, correct?
No sound, that's
All
right.
Would counsel please approach for just a moment? Members of the jury, I need to give you a limiting instruction at this time. The court has admitted the testimony of this witness only for a limited purpose. Similarly, the court has admitted Exhibit D-TR-67 for the same limited purpose, and that is, you may consider this evidence only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. I've explained to you in the past that when I refer to the issues raised by the defendant's plea of not guilty by reason of insanity, I am referring to issues related to two questions. Number one, whether the defendant was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act. And number two, whether the defendant suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an element of a crime charge. Does everyone understand that? And everyone's saying yes and nodding their head yes. All right, thank you. Okay, with that, Ms. Teach McGuire, do you have any cross-examination?
Your Honor, I do. I would ask to be permitted to cross-examine him after the video show, but we just received a copy of this right now, so I would ask the court for permission to have a short break to review it.
Is there any way you can view it on your laptop? That's fine. It'll be easier.
Your Honor, I've had a brief opportunity to review the video, and it can be published to the jury
All right,
without people's objection.
okay. Mr. King, do you want to publish it right now?
Yes, Your Honor.
Okay. Do you want me to dim the lights?
Yes, please.
All right.
Need the desk.
right, the record should reflect that the defense just finished publishing Exhibit D-TR-67. Is there a cross-examination?
Good morning, Mr. Pring.
Good morning.
This wasn't the first opportunity you had to observe the defendant.
No, it wasn't.
In fact, was your first contact with the defendant on July 23rd of 2012?
Objection beyond the scope.
Overruled?
I believe so. I don't know exactly which day it was that I first met him. It was, I think, maybe the second day that he had arrived to the jail.
As a nurse at the Arapahoe County Jail facility, do you take notes that document your interactions with inmates?
Yes, I do.
Did you meet with me and have an opportunity to review those notes? So would it be a surprise to you if you noted that your notes noted that you had contact with him on July 23rd of 2012?
No, it wouldn't surprise me at all.
Can you tell the jury about your observations of the defendant on July 23rd of 2012?
He was, you know, like any other inmate, a little anxious when he first got there. He was for several months. Maybe a little hypervigilant, but mostly just anxious, which is very normal for inmates, especially in the first couple of months.
All right, and did he ever have any needs that he asked you about during that time on July 23rd?
Objection beyond the scope.
The objection as to beyond the scope is well, actually, why don't counsel approach, please? Okay, the objection is overruled. Ms. Stitch McGuire, you can proceed as we discussed.
Thank you, Your Honor. You also had contact with the defendant on July 24th of 2012, is that correct?
I believe so, yes.
Were your observations of the defendant consistent with the observations you would have of other inmates in the jail?
Yes, it was.
You also had contact with the defendant on August 3rd of 2012.
That's what the notes say.
And were your observations of the defendant at that time consistent with the observations of other inmates in the Arapahoe County Jail?
Yes.
And the same for August 8th, August 9th, September 3rd,
Yes.
all of those observations consistent with other
He's been very
inmates?
consistent.
Generally, your observations of the defendant was that he complied with orders?
Mm-hmm.
And what was the...
Hold on. Was the answer yes?
Yes.
All right.
Thank you, Your Honor. And your specific role as a nurse in the jail at that time, could you tell the jury about what that role was?
Basically, I tend to the medical needs and psychiatric needs of the inmates as they come up, especially when I'm working in booking. There's a lot of different things we deal with, but covering booking and inpatient at the same time can be a handful sometimes. It's a lot of work, a lot of people. Basically just tending to medical needs, emergencies, and anything else that may come up, including deputies.
So up until 4 months later, on this date when we saw this video, you never had any concerns at all regarding Mr. Holmes?
No, I mean, you're on guard with all the inmates, but no, nothing out of the ordinary.
Was the defendant able to answer your questions when he asked them up until that time?
Yes,
Did he answer them appropriately?
absolutely.
Did he react to stimuli appropriately?
Yes, he did.
Now, going to what we just saw in that video, as you were able to watch the video, were you able to notice that the defendant neatly placed items around his cell?
Yes, he's always been very neat like that.
Did you notice that he neatly placed the photographs within the blue sections of his cell?
Yes, he does.
Were you able to notice that he was able to walk effectively up on his bed without any assistance?
Yes.
And what were your observations? And to be clear, when you reviewed this video, you were doing so to make sure you didn't need to provide specific medical treatment to the defendant. So you were watching it with a careful eye to see if he could have been injured.
Yes, it was the only bit of information that I had to be able to evaluate him since he didn't want me to physically look at him.
And it's fair to say that that camera is easily visible to inmates in the cell.
Yes,
So inmates know that they're on camera.
yes.
And you, when you watched that video, please tell the jury about what you observed about the defendant.
Objection, Judge. That calls for speculation, for a characterization. The exhibit speaks for itself.
Sustained.
You had no concerns about any injuries to the defendant after your observations of watching that video.
No.
Did you also observe that there was a white powdery substance on the floor of the defendant's cell?
Afterward, yes, the deputies brought that to my attention and I could see it on their boots.
Okay. May I have a moment, Your Honor?
You may.
Did you have any contact with the defendant after the date of this incident of the video camera?
Multiple, up to current date.
Were all of your observations of the defendant after that date consistent with your observations of other inmates?
Yes.
I have no further questions of this witness. Thank you, Your Honor.
All right. Is there any redirect, Mr. King?
Just one question, sir. 3:32 hours, 3:32 in the morning?
Yes.
AM? Thank you.
Yes.
Any recross?
No.
All right. And the jury does not appear to have any questions for this witness. Mr. King, may this witness be released from his subpoena?
Yes, Your Honor.
Is there any objection, Ms. Stitch McGuire?
No, Your Honor.
All right, sir. Thank you.
Where would you like this to go?
You can put it on the table right
Okay.
there. Thank you.
Thank you.
Thank you. You too. Mr. King, please call your next witness.
The defense would call Dr. Jonathan Woodcock.
Good morning. Could I have you raise your right hand for me so that I can administer an oath? You solemnly swear or affirm on the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? All right, please be seated. Please tell us your full name for the record and spell your first, middle, and last names.
Jonathan Hugh Woodcock, Jonathan Hughwoodcock.
Mr. King, you may proceed with your direct examination.
Thank you. Good morning, doctor. How are you?
Good morning. Good, thank you.
Doctor, I'm going to have some questions for you about your training and experience, but first, before we begin, if at any point during our conversation here you think that you would like to look at your report or something else to refresh your memory, just let us know and we'll let you do that as long as we know what you're looking at. Is that okay?
Yes.
Tell us what you do for a living, sir.
I'm a neurologist and psychiatrist.
Can you tell us what's the significance of being both a neurologist and a psychiatrist, if there is a significance to it?
Well, there is some significance. Most people train in either one field or the other. I've always been interested in the impact of brain function on what we call higher cortical function, usually the categories of behavior, emotion, and cognition. And I felt early in my career that it would be helpful and interesting to me to train in both the fields of neurology, which is mostly brain function based, spinal cord based, and in psychiatry, which has to do more with emotional, psychological types of behavioral pathology. And throughout my career, I've specialized in basically the overlap of those two fields where usually identifiable brain dysfunction results in problems in behavior and cognition and emotional control.
In terms of the training that you received and the education that you received to have these qualifications, first of all, where did you go to college?
I went to college in Houghton College in upstate New York.
And did you then attend medical school?
Yes, I attended medical school at the State University of New York at Buffalo School of Medicine.
And what year did you graduate from medical school, sir?
1977.
And what did you do following your graduation from medical school? Were you involved in some residency at that point, or?
Yes, I did 2 years of residency training in internal medicine at Case Western Reserve University in Cleveland. And then I did 3 years of training in neurology at Massachusetts General Hospital at Harvard in Boston. And then 2 years of training in psychiatry at McLean Hospital, also at Harvard in Massachusetts.
So because of your dual focus in psychiatry and neurology, does that involve, is that why you had to have two separate fellowships there, or?
Yes, each field requires its own training program and examinations.
Following the termination of your fellowship in psychiatry at Harvard Medical School in 1984, what did you then move on to do as part of your training, or were you done with your training at that point?
I was done with my training, but hopefully not my learning. And my first job was to take over the psychiatric intensive care unit at McLean Hospital, which is one of Harvard's two teaching psychiatric hospitals. And it was, I was given the job by my chief to transition that program from a psychiatric intensive care program for people with principally intractable psychoses, schizophrenia. A lot of the patients there had to be very carefully monitored because of their suicidal and homicidal ideation, and to transition that program into a program for people with known or suspected acquired brain problems, such as traumatic brain injury, strokes, encephalitis, that sort of thing. A lot of those patients also have severe problems with behavioral control, and those were the types of patients in that category we were taking care of. So we had similar behavioral management techniques that the staff knew about in running the intensive care unit. And we were able to transition to a somewhat different population, again, that had problems with higher cortical function and different kinds of brain injuries.
Now, how big of a facility is this, just to give the jury some indication of the number of patients that would be at this psychiatric hospital at any given time?
The psychiatric hospital had, I think, about 300 patients. Our particular unit at any one time would usually have about 25 inpatients.
And you indicated that you were the psychiatrist in charge, is that right?
Yes, I was one of two psychiatrists in charge.
Did you also have direct contact, clinical contact with the patients, interaction with the patients, diagnosing them, treating them, things along those lines?
Yes, it was my job to, first of all, establish the program, to supervise the nursing and therapy staff, and to evaluate the patients, as well as treat them throughout their hospital course and arrange for follow-up care after they had been discharged.
And I think that you said that part of your task there was to manage this transition. And I think you said the transition was from a psychiatric intensive care type unit to more of a traumatic or injury or neurology-based practice. Is that fair to say?
Well, the patients that we were seeing in the program were transitioned from the patients who had diagnoses usually of psychotic disorders. That would mostly be schizophrenia, schizoaffective disorder, and bipolar disorder, as well as other types of severe, usually personality disorder, where there was either aggressive behavior or suicidal behavior, mostly suicidal behavior on that unit. And then we began to admit and to see and develop a program specifically for people who had acquired brain injury, such as strokes and traumatic brain injury.
So over the course of time that you were there, and that was, how long were you there?
I was there almost 5 years.
Over that 5-year period, did you see a significant number of patients that had serious psychotic illnesses, as you described, schizophrenia, bipolar disorder, or schizoaffective disorder?
We began with that population, then we moved on to this population with acquired brain injury. So those people had what we would call organic psychotic or organic affective disorders. But during that time, I probably saw hundreds of people who met that category.
And what did you do after you were done with your tenure there, that 5-year period there, which was, what, 1989 you were done there? Or?
Yes.
What was the next step in your progression?
In 1989, I was recruited to come up and set up a similar program here in Colorado. And we did that. That program started out in Boulder and moved to Louisville and closed in less than 2 years. And then I was recruited to be medical director of a rehab hospital that wanted a similar program. So I continued to run those programs in several different facilities, but it's basically the same model for the same population of patients for another 15 years.
And during that period of time when you were had those administrative responsibilities, did you also have a private practice, a private psychiatric practice?
Yes, I had a private practice both in Boston and here in Colorado.
And what did that entail?
It basically involved seeing patients with similar kinds of problems, but who were outpatients, who were in the community, or sometimes living in residential facilities. But they were able to come basically to an office and see me, and then I would do a similar sort of evaluation that we would do in the hospital and arrange for them to receive appropriate therapies in the community, working with various therapists who understood the needs of these patients as well as manage their medications.
Now, during your private practice, have you been retained to do any forensic work? Have you, meaning testifying in court or having court-related professional activities?
Yes, that's been an important part of my career in taking care of people with acquired brain injury. Many of those people have traumatic brain injuries or have been through some medical procedure which results in the neurological problem. And some of those people are involved in lawsuits, in litigation about the causation and the damages that they've sustained. And therefore, lawyers began to ask me, because I was treating these folks, specific questions about the causation or the needs that those people would have over time, and that became a significant, a minority, but a significant part of my practice. I also was asked, I've also been asked a number of times in terms of criminal cases where the question would be whether someone's neurologic condition or psychiatric condition or both had contributed to their criminal behavior.
So in that context, have you done both work in the civil arena and the criminal arena?
Yes, mostly in the civil, but some in the criminal.
And in the context of your forensic work, well, first of all, did you ever receive any training in forensic work as part of your education or as part of your continuing medical education or training outside of your formal schooling?
Yes, I have in my psychiatry training program at Harvard. Our chief of psychiatry had been the chief of correctional psychiatry in Texas before he became a professor at Harvard, and ran our program. Was very interested in correctional psychiatry as well as in forensic psychiatry, and so I think our program was probably very strong in terms of training in those areas. Part of our training involved a rotation, for instance, at Bridgewater State Hospital, which then was the correctional psychiatric hospital in the Massachusetts correctional system.
So did you both in Massachusetts and in Colorado conduct sanity evaluations of criminal defendants, for example?
I was trained in doing that in Massachusetts and did some as a trainee. I didn't do it as part of my professional career there, although at least in the criminal area, I certainly did a number of competency evaluations regarding things like financial decision-making, end-of-life decision-making, and that sort of thing. And then my involvement in criminal evaluations has been in Colorado.
How many criminal, have you both been involved in criminal cases where you've testified ultimately at a trial or a hearing? Have you done that?
Yes.
And have you also been retained in criminal cases where you've been more of a consultant or where you haven't actually, it hasn't actually gone to trial, the case?
Yes, more often it's been that case where I would do an evaluation and it would be determined that I wouldn't testify.
So give us a rough example of how many criminal cases do you think you've been retained on? Total?
I think I've probably been retained in 1 to 2 dozen cases, and I think 4 of those have gone to trial.
Okay. Murder cases?
Yes, there was, I think, 3.
Have you ever been, in your civil work, have you been retained by both sides, the plaintiff and the defendant at different times?
Yes, I have.
How about courts? Have you ever been appointed by a court?
I've never been appointed by a court.
Okay. In criminal context, have you ever been retained by a prosecutor, or have the cases you've worked on been for defense lawyers?
All the cases I've been asked to do have been defense.
Is that because of some ethical or moral position you have, or is that just what's been offered to you that fit your schedule?
No, it has nothing to do with my bias. That's just who's called.
What kind of professional organizations are you a part of, sir, that would be relevant to your testimony here today?
I'm a member of most of the professional organizations that, with my background, you'd sort of expect me to be a member of, including the American Academy of Neurology, the American Neurological Association, the American Psychiatric Association. I'm a certified member of the American Society of Neurorehabilitation, the Society of Cognitive and Behavioral Neurology, the American Neuropsychiatric Association, Colorado Society of Clinical Neurologists, and the Colorado Psychiatric Society.
When you were working at the McLean Hospital in the 80s, late 80s, as one of the two psychiatrists in charge, were you also teaching at that point in time?
Yes. We had both medical students and residents who rotated through our program, and then there would also be other seminars that I would provide to usually the residents.
And that would be associated with the Harvard Medical School?
Yes.
And since you've come to Colorado, have you had other teaching positions? Do you teach about psychiatry or neurology?
Yes, I've been a teacher here since shortly after I came, because it's one of the things that I enjoy, and I learn a lot by doing it. And I was first on the volunteer neurology faculty, and then also had an appointment in the rehab department. We had rehab residents rotating through our programs here from the university as part of their training in rehabilitation for acquired brain injury. And 2.5 years ago, I accepted a full-time appointment on the full-time faculty in the Department of Neurology in setting up the clinical dementia and dementia research program, and have been actively teaching during these 2.5 years as well.
Are you board certified, sir?
Yes, I'm board certified in internal medicine, neurology, psychiatry, and the subspecialty of behavioral neurology, neuropsychiatry.
Judge, at this time I'm going to move for the admission of Dr. Woodcock as an expert in the fields of psychiatry and neurology pursuant to Colorado Rule of Evidence 702 and People v. Schreck.
Is there any objection? Yes. Mr. Bruckler, you may conduct some voir dire.
Thank you. Good morning, Doctor.
Good morning.
I want to talk to you about some of your experience and some of the things that you testified to, okay?
Certainly.
First off, when you were asked about your background regarding specifically forensic training, you referred to a period of time back when you had been trained at Harvard. Is that fair?
Yes,
What year was that?
that would have been from 1982 to 1984.
Outside of 1982 to 1984, which I believe was President Reagan's first term, did you have any other training in forensic psychiatry?
Yes, I've taken courses in forensic psychiatry at the American Psychiatric Association meetings. In our section, which we call the behavioral neurology section, we also have an interest in this area. And we actually have a forensic psychiatrist who's part of our section. So we have periodic conferences in this area. The psychiatry program where I have an appointment, the psychiatry department, also has occasional rounds or lectures in this area. And I also do a fair amount of reading in this area.
So lectures and reading are things that you participate in since 1984?
Yes.
All right. Now, to be fair, your current position, you are listed on really all the CU websites and information as an assistant professor of neurology, correct?
No, I think it lists me as an assistant professor of neurology and psychiatry.
Would you recognize a copy of the website if you had a chance to look at it again?
I probably would.
May I approach the witness, Your
I
Honor?
don't look at them often.
You may.
I've got a couple versions of this, sir. I'm handing you what I think has been printed out yesterday from the CU website. Do you see that?
Yes.
What does it say you are?
It says an assistant professor of neurology on this website.
Now, in fact, if you go to the neurology website, it lists all the faculty there. You're aware of that.
Yes.
And it lists you as faculty there. Fair?
Yes.
If you go to the psychiatry website for CU, it lists the faculty there. Fair?
Yes.
You are not on that. Fair?
I don't know. I haven't checked it.
If I handed you a printed off copy of that, would that help?
It would. I haven't looked
Judge, I'm
at
going
the
to
site.
object. It's not going to refresh his recollection if he's never seen it.
Well, I don't think he's, are you using it to rephrase his recollection?
Well, have you ever seen who they list as faculty on the psychiatry website?
No, I've never looked at that.
Would you take me at my word if I said you're not listed on there?
That wouldn't surprise me.
Okay.
I have an appointment in psychiatry as an assistant professor.
I understand.
Thank you.
In fact, the two things that you are listed for on the website are related to, since 2012, are specifically regarding the Rocky Mountain Alzheimer's Disease Center. Fair?
Yes, that's my primary job.
That's your primary job, is dealing with Alzheimer's. And then there's some research related to dementia.
Yes, I'm also the director of clinical research for the Alzheimer's program, which is our umbrella term for dementia.
And that has been the focus of your practice, really, since you took over this appointment as assistant professor?
That's been a principal focus, yes. It's not the only thing that I do.
I understand. One of the things that you were asked about was the times that you have testified in cases. Do you recall that?
Yes.
So I'm looking at the times that you've testified, and it appears that you testify more in depositions in civil cases than in trials. Is that accurate?
Yes, most cases settle before trial, so that they'll settle usually after the expert's deposition, or I may be deposed as a treating physician, and then the case will settle before trial.
And to give some perspective to the testimony, I just want to go through. You've done, by my count, according to what you supplied to us, you've testified 25 times in trials of all kinds between 2010 and 2015. Is that accurate? Does that sound right?
That sounds about right.
Of those 25, 15 of them have been as an expert for a plaintiff in a civil case. Does that sound right?
Yes.
And so that we're clear, when you testify in a civil case for a plaintiff, you're testifying for someone who is suing somebody else for money for injuries they claim they've suffered.
Well, I'm not testifying for them. I'm testifying at their request, but I'm testifying for my professional opinion.
I understand. 7 times, bless you, 7 times you've testified in a civil case as a treating physician since 2010. Does that sound about right?
Yes. Most of the time I'm asked by the attorneys who are representing patients I'm seeing, either as a treating physician or as an expert.
And then one time I found between 2010 and 2015, have you testified for a civil defendant, usually a company or an insurance company or someone who's claimed to have caused the injury? Fair?
Yes, most of the defense, the civil defense work I do settles before deposition.
So the answer to my question is yes, one time between 2010 and 2015 you've testified at trial for a civil defendant.
That may be.
Okay. And one time you testified at a domestic relations hearing or trial between
Yes.
2010 and 2015, is that right?
Yes.
I also see that between 2010 and 2015, I have down here, based on your records, that you have testified in 1 criminal case. Is that accurate?
Yes, I think it is in the last 5 years.
And that criminal case was a murder case. Fair?
Yes.
It was a murder case out of Colorado Springs. Fair?
Yes.
And the person that hired you for that case is...
Objection, Judge. Relevance.
Goes to his expertise, Judge. This is all stuff ferreted out in the direct on his qualifications.
Overruled?
And the person that hired you on that murder case back in 2011 was Mr. King.
Yes, public defenders.
Other than that murder case in the last 5 years, since 2010, you had indicated that you testified in 2 other murder cases as an expert, correct?
I didn't say it was since 2010.
No. I'm sorry, and forgive me, that was poorly worded question. I don't mean that. I mean, you have testified in 2 other murder cases other than that one between 2010 and 2015, so even before that.
Yes, they were some time ago. I couldn't find any records about them. That's from my recollection.
Well, and do you remember where they were?
They were both in Colorado. They were both in rural Colorado, I believe.
Now, would it surprise you to know that on prior disclosures of your testimony, going back to the year 2000, you don't disclose any other murder cases that you have testified in as an expert?
Yes, that's why I couldn't find them. They were before we were required to keep testimony lists.
When you say required to keep, what do you mean?
Well, it's my understanding that the federal courts require expert witnesses to keep, to provide lists of their testimony, and they tend to be asked for by in other venues as well. That's my understanding.
And you understand that rule to have only happened as of 2000?
I don't know when it started.
So the list of testimony that you've provided since 2000 isn't complete because it doesn't contain those cases you can't seem to remember. Fair?
No, I have to assume that those cases occurred before 2000.
Oh, before 2000 in Colorado.
Yes.
Okay, and you don't remember where they were?
No.
Okay. Is it fair to say then in the past 15 years you have testified 1 time as an expert in psychiatry or neurology in the state of Colorado, well, heck, in any state, on a murder case?
I think that's correct.
And is it fair too then that that's the only criminal case for which you have provided expert testimony in a criminal case, in the last 15 years?
I think in terms of testimony, yes.
Just that one in 2011?
I believe so.
And in that case, you were not qualified as an expert in forensic anything. Fair?
I don't recall specifically. I doubt I was.
Okay.
I don't know. I was probably just qualified in psychiatry.
Okay. All right, you're not aware of a criminal court in the state of Colorado that's ever recognized you as an expert in forensic anything, have you? In a criminal case?
No.
Now, in going through your testimony, where you have, I presume, provided expert testimony, either as a plaintiff's expert, treating physician, or that one time as a defense expert, here are the areas that I've found from your disclosure about what you've testified to. CSF leak post-surgery. What is that?
The CSF is cerebral spinal fluid. It's the fluid that surrounds the brain and spinal cord. So there was an injury to the base of the skull in sinus surgery, which resulted in a leak and symptoms.
Concussion, yes.
Yes,
Cervical whiplash, yes. Traumatic anxiety, yes.
yes,
Post-traumatic stress disorder,
yes,
post-surgical cervical myelopathy,
yes,
traumatic cranial neuropathies,
yes,
traumatic brain injury.
yes,
I'm going to mispronounce this, forgive me, doctor. Pudendal neuralgia,
yes,
Lewy body dementia,
yes,
complex regional pain syndrome,
yes,
headache,
yes,
septicemia,
yes,
cervical disequilibrium.
yes.
You gave me a funny
I'm
look.
not-
It was
well,
on
I'm
your
not
thing,
sure.
so you tell me.
I think there was a transcription error on that one. Probably
Okay.
cervical disequilibrium rather than cervical disc equilibrium, but that's all right. It's
Hold on, it should
close.
say cervical what, sir?
Just cervical disequilibrium.
What is that?
One of it's imbalance related to an injury to the neck. The neck's very important for balance because we move our heads a lot. And sometimes people have disequilibrium related to neck injury.
Mild or moderate traumatic brain injury
Yes,
and spinal cord injury pain syndrome.
yes,
You've also specialized, as we've said, in Alzheimer's and dementia, but also Huntington's disease. Fair?
yes,
And I want to be clear on this. I've read a whole long list there, and I'll repeat them if you want, but not a single one of those things is present in this case.
that's correct.
Fair to say then, Doctor, at least as far as we have documented, you have been qualified one time in one court at the request of the defense attorney here to render an opinion on sanity in court.
Yes, in a murder case. In a murder case, in a capital case.
Now, there's a difference, you would agree, between clinical and forensic practice of psychiatry.
No, I consider forensic practice a subset of clinical practice, and I think that that would be the universal opinion of people who practice in this area.
That's interesting because there's an actual certification for forensic psychiatry, isn't there?
Yes, there is. It's a clinical certification.
And the way we know that is there's this ABMS, which stands for what, sir?
I believe the American Board of Medical Specialties.
And they've said, hey, we're going to treat this as a specific subset of psychiatry, haven't they?
Yes, of clinical psychiatry. I believe you have to be a clinical psychiatrist to have that certification. It's a clinical specialty.
But again, it's a specialty recognized by this American board, right?
Yes, it is.
You don't have it.
No, I don't have that. I only have 4 others, but I don't have that one.
4 others, none of them have the word forensic in them.
That's correct.
Now, you're also familiar with an organization that you said you're a part of called the American Academy of Neurology. Is that fair?
Yes.
And you've been a member of them for a long time.
Yes, I have.
Okay. They have actual qualifications and guidelines for the physician expert witness. Have you seen those?
Yes.
You feel bound by them because you're part of this organization, right?
Yes.
Do you recall what it says about training and certification for physician expert witnesses like yourself?
Not specifically.
Would it refresh your recollection if you saw a copy of those guidelines?
Sure.
May I approach the witness, Your Honor?
Judge, may we approach?
Yes. objection is overruled, and Mr. Brockler, you may approach.
Sir, I haven't marked this, but I'm handing you a copy of what purports to be the American Academy of Neurology Qualifications and Guidelines for the Physician Expert Witness. Would you take a look at that, sir, and tell me if you recognize what that is?
It's a consensus statement from the American Academy of Neurology that's entitled Qualifications and Guidelines for the Physician Expert Witness, and it is dated June 25th, 2005.
Okay, and you're aware that that's the one that's still applied and in existence today in 2015?
I'm not aware of that. I don't know if there's been an update or not.
That's something you'd want to be aware of before providing expert testimony, doctor, is what the guidelines of your organization are?
I've recently reviewed the current guideline. I don't know what it's dated.
Well, take a look, if you would, doctor, then at the second page of this, actually, yeah, at the top. There's a part there that talks about training and certification.
Yes?
Tell me if I'm reading this wrong. Actually, would you read that part for us?
Section B, Training and Certification. Physician expert witnesses should be fully trained in a specialty and a diplomat of a specialty board recognized by the American Board of Medical Specialties or the American Osteopathic Association or by a board with equivalent standards and qualified by experience or demonstrated competence in the subject of the case. The specialty of physician expert witnesses should be appropriate to the subject matter of the case.
And to be certain, the American board that we talked about, that's the one where we talked about where there's a forensic psychiatry specialty, and you don't have anything to do with that. So.
No, absolutely wrong. That's not a fair characterization of this guideline.
Well, tell me.
The characterization of this guideline would be that the physician would be, in this particular area, board certified in psychiatry. Forensic psychiatry is a subspecialty of psychiatry, and not all psychiatrists who practice in forensic psychiatry or give testimony are board certified by that subspecialty board. So the relevant board here is the board of would be in psychiatry, the American Board of Psychiatry and Neurology with certification in psychiatry. And I qualify under this document and my training.
In your opinion?
Absolutely.
Yeah, fair. Can I ask you too, what's the difference between neurology and psychiatry and neuropsychiatry?
That's a very good question, and I get asked by my patients and families a lot. Neurology is the broad field of diseases that are identifiable in the brain and the spinal cord, and basically the muscles as well are included. This is common diseases like multiple sclerosis, stroke, those would be some of the epilepsy would be common diseases in that category. Psychiatry has to do with more cognitive and emotional problems, mostly emotional problems. So common diseases would be depression, bipolar disorder, schizophrenia, personality disorders, anxiety disorders, PTSD, that sort of thing. All of these diseases, whether they're neurologic or psychiatric, come out of the brain. They reflect brain pathology. But the approaches that we take in dealing with them are very different. So historically, the training in neurology and psychiatry became separate in the early part of the 20th century in this country, somewhat later in Europe. And people began to learn basically the treatment and diagnostic techniques of either neurology or psychiatry. But there are several hundred doctors in the country who've been interested in this overlap, how brain function is reflected how identifiable brain function or suspected brain function is reflected in how people think and how they behave and their emotional symptoms. And so there are combined training programs, and there are also specialty training programs. Our university, for instance, has a fellowship that's open to either neurologists or psychiatrists to learn about this overlap area. And neuropsychiatry is the term we use from the psychiatric side to describe this overlap. Behavioral neurology is the term that we use from the neurology side. So behavioral neurologists who specialize in that area call themselves behavioral neurologists. Psychiatrists who specialize in this area call themselves neuropsychiatrists. About 10 years ago, for the first time, there was a movement by both groups of physicians to come up with a combined single certification so that in neuropsychiatry, behavioral neurology, so whether you train in neurology or psychiatry, you can qualify to take this examination because it's really of the overlap of these two areas that are so closely related, but still involve separate training programs and separate certification under an umbrella board under the American Board of Medical Specialties. I hope that's clear.
And also to be clear, there's no recognized subspecialty by the American Board for neuropsychiatry.
Yes, I've just alluded to that. There's this board that's called the Board of Neuropsychiatry, Behavioral Neurology. It's not a board under the American Board of Medical Specialties. There's a separate board qualifying organization that I think is called, I'm not sure what it's called, but it is an umbrella organization for specialties that are not covered by the American Board of Medical Specialties. While specialization has continued up to the present time, the American Board of Medical Specialties made a decision many years ago that they would not basically continue to provide specialty certification in more and more subspecialties. So this other umbrella organization was set up to do that.
I want to go through a couple of things. Doctor, you'd agree with me that one of the potential measures of someone's expertise would be publications in their field?
Yes.
Okay, and you've had some publications in your field?
Early in my career, yes.
Right.
It's not been a major part of what I've done.
Yes, right. And any of those peer-reviewed?
Yes.
Which ones?
There was a article published in Stroke, which is a peer-reviewed journal on treatment of intracranial hypertension. I think the others were book chapters, and there was another more recently, actually, on medical legal consultation in neurologic practice that was published in a peer-reviewed journal.
Doctor, to be clear, I've seen one book chapter listed in your curriculum vitae. Is that it?
No, there have been several.
You just listed the one, though?
There was one on the assessment and management of violence. I don't know if that's there.
No. Would it refresh your recollection to see what you actually submitted as your curriculum vitae?
I'd be happy to look at
Yeah, thank you. And I just turned it to that page, forget my notes on there. But if you look at that, does that look like the copy of the most recent curriculum vitae that you not only submitted here, but that you have posted online at the University of Colorado for the Department of Neurology?
Yes, this is dated April 8th, 2015.
Help me figure out what's going on with the book chapters there. I see one on Huntington's disease.
Yes, that was published in 2 editions of that book.
Back in 92 and 99.
Oh, yes. The other one I was referring to is the review in psychiatric clinics of North America called A Neuropsychiatric Approach to Impulse Disorders. That's the other one I was referencing.
And is that a book chapter or is that a review?
The clinics, they call these clinics, it's a book with a number of chapters in it, which is published about 6 times a year. But if you look at it, it's a book. It looks like a book.
What year was that? Could you
It's a compilation of chapters. That was 1986.
86?
Yes.
May I approach the
You
witness?
may.
Thank you.
Mr. Brockler, it looks like the jury needs a break, so would this be a good time to break?
Judge, sure, yes.
Okay, all right. Members of the jury, let's go ahead and take our morning break. Please make sure that you comply with all the admonishments I have been giving you throughout the trial with respect to your conduct when you're not in the courtroom. I'll see you back here in 20 minutes. Thank you. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. My bailiffs received a note from one of the jurors indicating that he or she needed a restroom break, so that's why I interrupted the proceedings. All right, let's take our morning break, and I'll see you back here in about 20 minutes. The court will be in recess. Thank you.
Please rise.